Hey everybody, Andy Nelson. Today we're going to talk about mythology, and I don't mean Greek mythology. I'm talking about intellectual property mythology. And the number one myth, close to number one myth. I'll illustrate. So as a kid, I remember going into a gas station. They had a little spinner there with all kinds of sunglasses, and of course my budget back then was probably a whole like $2. And I'm looking at different sunglasses at the gas station of all places, and there, oh, lo and behold, there's a pair of Ray-Bans. Ray-Bans, oh wow, no kidding, really? Put these on. Only years later did I figure out, wait a minute, the company, the brand's called Ray-Ban, not Ray-Bans. Ray-Bans is that's how us consumers refer to them in the plural when we're talking about a pair of sunglasses. So my point is, we had a knockoff counterfeit brand, really, that just added a cute S to the end of Ray-Ban to try to separate itself from the actual product. And a lot of people I run into think that same way. They come to me and they say, oh, hey, Andy, I've chosen my typically this is with word marks, either single words or multiple words. And they say, well, I just added an S, right? I traded out a letter, so I'm all good. I'm in the clear. Whoa, hold on. Let's talk about this. Just making a minor change is probably not going to do it in most instances. Another myth that I hear quite a bit, which is passed around a lot, is, hey, if you just change your trademark, meaning whether it's words or if it's a graphic trademark, a logo, just change it by X percent. And usually I hear 30%, but it varies all the time, however it gets circulated. You just change it by 30% and you're in the clear. It's a safe harbor. You're good to go. And there's just no such rule like that. There really is no such rule, and I do not know why this myth continues to circulate. It's unfortunate because it gets a lot of people into trouble. A lot of people come to me or other lawyers, and they've already selected what they're going to do under the belief that because they changed a single letter, they added a Z instead of an S, or they took someone's logo and they just slightly altered it by what they consider X percentage, 15% or 30%, whatever myth was passed along to them, that they're completely in the clear. And that's just not the case. You got to go back to whatever their actual legal standards are. And I'm not going to get into those in detail, but the ultimate question with trademarks is there a likelihood of confusion as to source, sponsorship, or affiliation of the brands that are behind two marks that you're looking at? So, just saying you change a percentage is not going to answer that question necessarily. It might be relevant to answering the question, but it's not going to be determinative necessarily. So don't fall for those myths. If you hear people spreading them saying, if you just change this, you're okay. I've heard this so many times. It's not true. It's just not true. Or change this by a percentage, you're going to be okay. It's just not true. And likewise, do your buddy a favor, don't spread the rumor either. So anyway, it's a more complicated question. If you have wonders, if you're curious as to whether you might be running into a potential problem, consult with somebody. Consult with a professional who can give you a better opinion as to whether you might be stomping on somebody else's rights before you do so. Don't rely on what we call the barracks lawyers or what have you with some of these myths that circulate. I've seen this too many times. Anyway, if you have any questions about this video, feel free to shoot me a message, drop me a comment if someone would benefit. And there's somebody that will benefit from knowing this myth doesn't exist. This myth should be discounted. Share this with them, and hopefully we can help out a buddy. Anyway, have a good one. We'll talk soon. Bye-bye.